Good afternoon, everyone. My name is Marissa Thomas, with Legal Aid North, an attorney with Legal Aid North Carolina's Helpline. You are joining us today for Simple Divorce, Listen and Learn. Due to unforeseen circumstances, we will not have an attorney live to answer questions, any questions you may have today. If you have questions during the session, I encourage you to register for our next session, which will be in February, and I will post a direct link in the chat box on Zoom and the comment section on Facebook for you to be able to register for that next session. So for this time, we are going to play a prior recording of the Simple Divorce Listen and Learn, where attorney will review all the legal information regarding the simple divorce. And again, we will not be able to answer questions as we do not have an attorney to answer those questions live. And the session will end when the video concludes. Our apologies again, and thank you all for joining us for today.
Noon, everyone. So as Marissa stated, my name is Susan Yanagi. I'm a staff attorney in our domestic violence unit here at Legal Aid. And today I'm going to be presenting on simple divorce or absolute divorce. And so a little bit of background about Legal Aid. We are a statewide nonprofit law firm that provides free legal services in civil matters. So that doesn't mean criminal. We don't represent in criminal case matters, to low-income individuals to ensure equal access to justice. And so a couple of the areas of law that we assist with are housing. So we typically represent individuals that are being sued for like summary ejectments, so evictions. We help out with employment law, education, domestic violence protective orders, disaster relief, consumer issues, Medicare, Medicaid, healthcare signups, government benefits, veterans legal issues, human trafficking, and immigration issues. So as you can see, we cover a whole lot of areas of law within our organization. And so if any of those sound like an area of law that you may need assistance with, we have a phone number that you can call that's listed on the screen here, or you can apply online at legalaidnc.org. And so you can take down those. I'll leave that up for just a few seconds if you need to take those down or take a picture or whatever you need to do. Fun. And so I know Marissa's already stated this, but I'm just going to remind y'all again that Legal Aid is not your attorney. We are not representing you in your divorce matter. I'm simply here today to walk you through how to to file for a simple divorce or an absolute divorce on your own, okay? And, so what this presentation will do, it's designed to help you represent yourself, fill out the forms, and go through the absolute divorce process. And so what we'll do is we'll first make sure this filing is right for you. What I mean by that is, should you be filing? Are you filing in the right state? Should you be filing now or should you be filing later? And what I mean by that is, maybe you have some property that needs to get sorted out, those kinds of issues. And we'll get into that a little bit more later, but those are the things that we're going to address first. And then what information you need to have in order to file for divorce, what documents you need to have at the ready in order to properly fill out your paperwork. And then we'll talk about filling out those forms and how to go about filling out those forms and the actual process that gets you that judgment signed by a judge stating, hey, I am divorced, which is the goal. So first, is a simple divorce right for you? So a couple of the questions that you need to ask: have you or your spouse lived in the state of North Carolina at least 6 months on the date that you file for a simple divorce? So if you just moved here a month ago from, let's say, South Carolina, and you want to file for divorce here in North Carolina, you can't. You have to wait 5 more months, or at least until you've lived for 6 months here in North Carolina. Or if you live out of state, but your spouse has lived here for the last 6 months, you can file for a simple divorce here in North Carolina. And so, like I said, if your answer is no to that, wait until at least one of you or both of you have lived here for the last 6 months. And so the second question is, have you been living separate and apart for an entire year prior to the date that you're filing? And what we mean by separate and apart is literally separate and apart. There's been no try again periods. There's been no times where you've tried to reconcile, you've moved back in with one another to try to make it work, but then it didn't, so you separated after a month. Nope, we're not talking that. We're stating that you have to live in two separate addresses. So one person has their own house, the other person has their own house or apartment or whatever, and you don't cohabitate together. So that means you can't live in the same house during that period of year. So it doesn't count as separate and apart if somebody stayed in a separate bedroom or somebody took the first floor and somebody took the second floor. So overview, one of you has had to live here for the last 6 months, and you had to have been living separate and apart for that entire year prior to the date that you file. Now, a couple of warnings. If you have any property together, let's say you bought a house during the marriage, or you bought cars that has both of your names on them during the marriage, or if you're seeking any type of spousal support, an entry of a judgment of divorce will affect your rights to this property. So that will affect equitable distribution or post-separation support and alimony. So once there's a final judgment of divorce, you can't go back and ask for property rights. You can't go back and ask for spousal support. That has to be done prior to you filing for divorce or prior to the entry of the divorce judgment. So if you want to divide property or any type of money, or if you want to seek alimony from your spouse, you need to speak to an attorney before you file anything, because there's different timelines for those types of things. And the divorce process, honestly, if you're filing for an absolute divorce, it moves pretty quickly. And equitable distribution and spousal support, all of that takes a little bit more time. So if you have stuff like that, or you're thinking you may want spousal support or alimony, you need to talk to an attorney prior to filing. Now, a simple divorce does not have any impact on your custody rights and the children that you share with your spouse. That is addressed in a separate action called custody, like filing a custody complaint. It's not addressed in the simple divorce. So if you have children and you want to file for custody, that's going to be a completely separate action. And it also does not have any impact on child support. Same thing, you would have to file a separate action for child support. So what information do you need in order to properly file your complaint? So you're going to need some information about yourself, and you're going to need some information about your spouse. For you, you're going to need your full legal name, your address where the court can mail you documentation, your marriage license if you have it. And the reason for this is because you need your marriage date. Okay. You'll also need your children's full names and dates of birth. And those, by children, we mean those that you share with your spouse that are under the age of 18. So minor children. Okay. If they're over 18, we don't include them. If they're under 18, we include them there. And then the location of the clerk of court in any county where you plan to file. Okay. And then for the information regarding your spouse, you're going to need their full legal name, their current address, and then their military status, whether or not they're currently active in the military, inactive, or have never served. Other things you'll need is a printer in order to print out your documentation, or a way to take your files to be printed out somewhere. So local libraries are a great option for that. And some courthouses do have printing stations where you can print. But if you're not sure, check with the clerk of court before you make a trip in. You'll want to find a location for a notary. And a lot of times those notaries charge a certain amount per signature, I believe $5. So make sure that you have a location and the money in order to be able to get your documentation notarized. And then a location of a post office close to the clerk of court, because after you file your documents, you're going to want to mail off a copy to your spouse as soon as you can. You don't want to sit on that. And so the slide has changed a little bit. There's technically two ways to file. So there's downloading all the forms that you'll need. And then you can hand fill out your form and then file with the clerk of court. However, in a lot of counties now, there's North Carolina Guide and File, okay? And so what Guide and File is, it goes through this 1-hour interview. It's a survey that gathers all of the information that we talked about on the previous slide, and it fills in the forms for you. And so the interview will be shorter if you have all your information together. And then you can print the forms with you're done and then file those documents with the clerk of court. But honestly, the guide and file is a lot easier process. Your county does not have to have e-filing in order to use the guide and file. It's simply filling out the paperwork for you. If you have, if you live in a county where e-filing does exist, there will be directions on how to go about that when you get done with guide and file in order to file your documents in your county. So this is what it looks like, eCourt's guide and file. And so like it gives you a little bit of background, free online service to help you prepare your documents. And then number one, it's free to use and you can stop and start as needed. So it's a great resource. I fully recommend using this because it's a lot simpler to understand and it looks clean when you print it out because everything's typed in for you. And so that's the link where you can go to access the guide and file. This is Blue Blood versus Blue Bud is a simple walkthrough of a divorce on North Carolina guide and file. So you can use that to help you go through that. And then there's the alternate of downloading the forms. And so the forms, what you'll need is the complaint, the civil summons, the domestic civil action cover sheet, and the screen that just popped up next to it where it says form number. This is where you can look up the documents on the North Carolina Judicial Branch website, the North Carolina NCAOC.org. And so on the screen, we have the name of the forms, but also if you just type in those numbers, which is AOC-CV-100 or 750, you'll be able to get that form popped up right where you need it. You'll also need the Service Member Civil Relief Act affidavit, and then an optional petition to proceed as indigent. And we'll talk about that in a minute. Affidavit of indigency, and you'll also want to make sure to check with your county about any extra forms that they may require. Some require additional, some don't. And then once you have all your forms, you're going to file them. And so what you'll need is 3 copies of your complaint. And what the complaint is, that's where you're listing out, you know, my name is, this is my full name. I've lived in North Carolina for this long. I was married on this date. We have this many children together. All of the information is going to go in your complaint. And then it also tells the court what you're looking for, which is a simple divorce. Now, the domestic civil action cover sheet, that's just a sheet that goes on top of your paperwork that says what you're filing for, the names of the parties, the addresses, just so the court can easily put that into their system so they have you on file as filed for a divorce in whatever county that you're filing in. Now, the civil summons is a very important document. That's the document that is going to let the individual, your spouse, know that they're being sued for divorce. That's what we call it. Anytime you initiate a civil action, it's a lawsuit, and that they have a certain amount of time to file an answer or to respond to the complaint. And that also lets the court know that they've been served with these documents, because unfortunately you can't move forward with getting a divorce or any type of outcome in a civil matter without what we call service. And so some counties require 2 copies of the civil summons be printed on yellow paper. Make sure you check your clerk for that. And then the Service Member Civil Relief Act affidavit, that's where you're just letting the court know whether or not your spouse is active in the military or inactive, okay? So basically, you're gonna need 3 copies of all of these documents. What I recommend doing, like if you're using eGuide and file, that'll be easy. It'll like type it out all for you. So you just print 3 copies of each. If you're handwriting and filling in your documents, fill out 1 set and then make copies, make 2 extra copies, and don't put yourself through the trauma of having to fill out each document 3 times. Your hand's going to hurt by the end of that. Make it simple for yourself. And then optional is the petition to proceed as indigent. And so basically what that says is that I don't have the funds in order to file for a simple divorce. Each county, I believe it's $150 and maybe $200, but it's somewhere in the $150 to $200 range to file. If you can't afford that, that's where you fill out the petition to proceed as indigent, okay? So filing. Make sure you don't sign anything early. So go through the guide and files, type in all your information, print everything out or fill everything out, but don't sign anything yet because there's going to be some forms that need to be signed by a notary as well, or in front of a notary. And so make sure that you have your necessary numbers of copies and that all the documents are signed in front of the notary when time comes. Once everything's signed and notarized, go to the clerk of court in your county and provide them with the paperwork. They will file stamp the paperwork. They will assign a CVD number. So it's going to say 24, which means the year that it was filed. So 2024, 24. And then it'll follow with CV or CVD and then a number after that. And that's going to be your file number where you can provide the court going forward to make sure all your documents are connected and to get updates on your case as well. And then they're going to hand you out your extra copies back to you because there's a couple things that you need to do with those copies, which is serving the defendant. So you're going to, one copy is going to be for the court to keep on hand. One copy is for you. One copy is to make sure it gets to the defendant. So there's different ways to serve. You can have the sheriff serve the documentation, and each county works differently. Sometimes in some counties, you just let the clerk know, I would like this to be served by sheriff, and they send it down to the sheriff's window. Other counties, they may have you go to a different location or a different place within the courthouse or clerk's office where you go and you let them know that you would like the sheriff to serve the documentation. And what that entails is the sheriff will go out to the address that you have listed on the civil summons. They will knock on the door and they will attempt to serve the defendant. Another way to serve is by certified mail. So you can go to the post office. You can ask for the certified mail little green sheet that you attach to your envelope. You fill that out because it will require the defendant to sign for the documents, and you can mail it out to the defendant that way. Or if those two don't work, you can do publication. And what I mean is if you can't serve the defendant by sheriff or certified mail, then you can post it in the newspaper where in the county where the defendant resides for a certain amount of time. And then you would provide proof to the court that they've been served or that you've had to go serve them that way because you haven't been able to achieve service by sheriff or certified mail. But that's like last resort. Focus on sheriff, certified mail. Some of you may have a spouse that's on board with getting a divorce as well, and they may be willing to accept and waive service. And there are forms available at certain court clerk's offices. So check in with your clerk's office if like the defendant's willing to go with you to accept service when you go and file the documentation. Like I know Mecklenburg County has that, but check with your courthouse to see if like the clerk of court has a form like that available. So if you both are willing to work together, it's a faster and easier process that way too, to accept service. So when you mail out the documentation or have the sheriff serve, the defendant must get a copy of the complaint and one of the summons in order to be properly served. And then there must be proof in the court file that they were served. If it's served by sheriff, they will send that proof back to the courthouse indicating the date and time the defendant was served. Certified mail, or publication, that's going to be on you. So like I said, sometimes this process can be done at the clerk's. And you'll provide the sheriff's department, if you have to go there, one copy of the complaint and 2 copies of the civil summons. There is a $30 service fee unless your filing fee is waived. And that's where the petition for indigency will get that waived for you. And so the deputy who serves the defendant will get that document back to the clerk and it'll show in your file that they were served. And you will need to keep in mind the date that the defendant was served. So once it gets sent back to the courthouse, make sure you're staying on top of your filings and staying in touch with the sheriff's department so you know when, so you can go and get that date that they were actually served, because you'll have to put that on documentation. You may have to put that on documentation later, or keep that in mind based on filing times for later documents that we'll get to. So certified mail, 1 complaint, 1 civil summons to put in an envelope and take to the post office. The green card that they'll provide you, you'll put the defendant's name and address on it and pay the postal fee. I believe that fee is It's typically not more than about $10 at this point. Now that green card, once it's signed by the defendant, will come back to you and it'll show the defendant's signature, and they'll have had to write the date that they received that document. And you'll want to keep that to show that the defendant was actually served. And so once you get that green card back, you're going to have to file what we call an affidavit of return of service. So you can get this form on the NC Courts website, the NCAOC, the NC Courts website. And what you'll do is you'll fill that in, get that notarized, attach your green card to it. And then you'll file it with the clerk of court in order to show that the defendant was served. I talked about this a little bit, but acceptance of service. Again, your spouse must be willing to sign this. You can't force them to, but if they're all on board with the divorce, use this acceptance of service form. The defendant will need to get it notarized as well. So have them meet you at a notary if they're willing to accept service, and then you can file it. They don't have to be with you when you file it. They just need to get the form filled out themselves. And again, keep record of the date that the defendant was served, as indicated by the affidavit, by the date that the affidavit was signed by the defendant. Publication. Again, means of last resort. So you must use reasonable means to define the defendant first. So again, attempting to serve by sheriff or certified mail, internet search, contacting friends or family, DMV information, private investigators. Once you utilize the majority of what's mentioned here to try and find them and you still can't, that's when you go to publication. And so you can contact your local, if you know that the defendant lives in the same county that you do, you'll want to contact the newspaper that is countywide circulating and ask them how to go about placing your ad in the newspaper. And they'll know what you need to do. They'll walk you through it. Most of them are very familiar with this type of process. So you're not going to have to know exactly what to write or anything. They'll walk you through that step. And then contact the clerk to see if there's any other requirements before using publication, okay? So the entry of judgment. Judgment, so there's a couple ways to have the divorce entered by the court. There's a judgment of absolute divorce before the clerk, and then there's the uncontested testimonial divorce before the judge where the judge signs off. And so the procedure for entry of an absolute divorce may vary from county to county. So contact your clerk of court or family court to determine if there are local rules you need to know about, forms, or customs applicable to the county where you filed your divorce action. Testimonial divorce hearings. So you must wait at least 30 days from the date that the defendant was served. That's why we keep harping on why that date is important. So you file the complaint, you get them served 30 days from the date that says that they were served with the documents. So the date that they signed, they received them on that green card, the date that the sheriff served them, you need to wait at least 30 days from that date before filing for the next step for a judgment of divorce. So on day 31, contact the clerk's office to determine what date your divorce hearing can be set for. And so you will need to file the following documents in order to get that hearing set. Those documents are a notice of hearing and a certificate of service. Some counties require you to file additional documents, so make sure you contact the clerk of court to determine if there's anything extra. All right. And you will need 4 copies of these documents that you are filing for a hearing before a judge, okay? And then once you have you're not going to mail the notice of hearing without the date attached to it. So the notice of hearing is letting the defendant know what day your divorce action is going to be heard, meaning when it's going to be signed off on, when the judge is going to issue that judgment. And so the defendant's going to need to know what date that is. So the notice of hearing, you'll get that date. And once the date is on it, that's when you'll mail a copy of it to the defendant. Some counties only conduct divorce hearings on particular days of the month, and so you want to make sure you're providing the defendant with as much as advance notice prior to that hearing. Provide your spouse at least 5 business days prior to the hearing. That excludes weekends and court holidays, and you must also include an additional 3 days for mailing. Okay, so I always say it's better to say like 10 days, makes it a little bit easier. Not providing your spouse with sufficient notice of the hearing may result in the judge not hearing your divorce that day and continuing your case. So when in doubt about dates, it's typically better to add a few extra days as insurance. So testimonial divorce. You're going to prepare the following documents and bring them to court the day of your hearing: the judgment of absolute divorce, the certificate of absolute divorce or annulment, and the AOC CV 711, that's the form number for that, and a stamped envelope with the defendant's address on it, so you can mail them a copy of the judgment of absolute divorce. So you're going to need 4 copies of the judgment of absolute divorce, and you'll need 1 copy of the certificate of absolute divorce, and you will need to fill out these forms on the computer and print copies to take to court. And we have only provided sample forms, but your county may have pre-filled forms available. Check with them. And so the hearing, what to expect. You're going to need to bring 4 copies of the completed judgment and the certificate of absolute divorce. These are in your guide and file package. But again, check with your county to see if there's anything specific that they want. You're going to want to dress business casual. So you don't need to wear a suit, but typically, guys, if you have dark, like black pants, khakis, and like a button down, or a polo, that would be appropriate. Ladies, dress pants, a skirt with a nice blouse, something along those lines. Don't show up to court in sweatpants or pajama pants. That never looks good. And you're going to want to arrive at least 15 minutes early to ensure that you're on time. If you get lost, you have enough time to find out where the courtroom is, all of those things. Sit outside, sit either outside the courtroom until the courtroom is unlocked. And once you're inside, sit where they tell you, where the deputies or the clerks tell you to sit, and wait for your case to be called. When your case is called, you're going to want to approach the judge's bench. You're going to want to be sworn or affirmed, meaning swearing on the Bible or affirming that you're going to tell the truth. And then you're going to take the witness stand. And the reason why you're taking the witness stand is just to tell the court the names of the parties, date you were married, the date you separated, how long you've been separate, where y'all live, North Carolina, how long you've lived in North Carolina, any minor children, all of those simple things that you put in your complaint. When you're testifying, speak slowly and clearly so the judge can hear you. And use your judgment of absolute divorce as a guide for your testimony, because basically that's the information the judge wants to hear. So this is what a judgment for absolute divorce looks like, okay? And so findings of fact, plaintiff, defendant is a resident of, that you've been here for more than 6 months, the dates that you separated, all of that will be listed. And so this should print as part of your guide and file packet as well. Make sure you take 4 copies. If the judge grants your divorce, you may ask, he may ask you for this so that it can be signed directly in court. If your county has e-filing, they'll just be able to, they may ask, if everything's already scanned into the e-filing system, and your clerks will be able to guide you through that if that's how that they want that submitted. They might be able to just pull it up on their screen, sign it, and you should be good to go. But always have hard copies just in case. Be sure to mail a copy of the judgment on the date that you indicated on the certificate of service to the defendant. So if you say that on the certificate of service am mailing the judgment to the defendant on September 19th, mail the judgment on September 19th. Mail it on the date that you have listed there. So this is the certificate of absolute divorce. This should also print with your guide and file forms, okay? And the clerk will fill out the remainder of the form. So you're just filling out plaintiff and defendant information and then your marriage information. That's it. After the hearing, The judge will then determine if your divorce should be granted after listening to your testimony and examining the documentation that you have filed. And then you're going to send it to the defendant if they're not there. If they are there, simple, you can just hand them a copy of the judgment of divorce after, or they can get it themselves from the clerk of court. And so make sure if you are mailing to complete the certificate of service for the judgment of absolute divorce, mail that copy, and then keep a copy of the judgment in a safe location with all your other important papers. So if you have a safe, keep it in there. If you have an envelope under your mattress, keep it there. Keep it where you have your important papers. So if you ever have to refer back to it because people are questioning if you're divorced, you could say, yep, absolutely. Here's the judgment. Here it is. If your judgment included a provision for a name change, you may want to obtain at least 2 certified copies of the judgment of absolute divorce for Social Security or DMV. You can ask for the judgment to be certified by the clerk of court. So that's simple divorce in a nutshell. Like I said, if you need services beyond this webinar, like you saw something at the beginning of the type of areas of law we also help with, and you need assistance there, you can call our number 1-866-219-5262, or you can apply online at legalaidnc.org. And that's all I got.
We're going to open it up for questions. You are free to put questions. All right. As I mentioned at the start of the session, we do not have an attorney here to answer any questions live, so I will be ending the session. I did put in the Q&A box on Zoom and in the comment section on Facebook a link to register for our next Simple Divorce Listen and Learn, which will take place on February 20th at 2:30 p.m. If you would like, if you have questions, there should be an attorney at that session to answer any of those questions live. If you also would like to review any of this presentation or any of the other past presentations, you can do so on Legal Aid of North Carolina's Facebook page. You can access the recording with or without a Facebook account at www.facebook.com/legalaidnc. If you would also like to register for one of our other Listen and Learns, such as child custody, tenant rights, Medicaid rights and eligibility, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a good rest of their afternoon.